In debt recovery, how you start often determines where you end. In Vietnam, the most effective creditors do not begin with lawsuits, they begin with soft collection. Not because they are hesitant, but because they are strategic. In this final video of our soft collection series, we explain why soft collection should usually be your first move in Vietnam's recovery process, and how it gives you more control, better options, and fewer unnecessary legal battles. Soft collection is not a polite request or a casual follow-up. Done correctly, it is structured engagement, disciplined communication, defined deadlines, and clear escalation readiness, without prematurely triggering formal proceedings. At LTS Law, soft collection is designed to influence behavior through clarity and credibility. We structure the message, document the timeline, and position the creditor properly from the very first step. The debtor receives a clear signal: this matter is being handled professionally and will not drift. Beginning with soft collection offers 4 advantages. 1. Speed. Many matters can move faster than litigation when a debtor is still operating and willing to negotiate. Results depend on facts and cooperation, but soft action often shortens the path to payment. 2. Cost control. You avoid immediate court fee advances and arbitration costs, and you invest first in targeted steps. 3. Relationship preservation. When the dispute is a delay, not fraud, soft collection can solve the problem without destroying the commercial relationship. 4. Better legal positioning. If escalation becomes necessary, you already have a structured record of notice, communications, and attempted resolution, often useful in later proceedings. Soft collection is often most effective when started early, commonly within the first few weeks to a few months after an overdue payment arises. This is when debtors are more responsive, reputational concerns still matter, and business operations are still active. Delaying too long reduces options, evidence becomes harder to organize, communication goes cold, and the debtor may restructure or disengage. Starting early does not mean escalating aggressively. It means controlling the timeline before the debtor controls it. Soft collection is not only about recovery, it is also about reducing legal risk. Every compliant letter, each documented deadline, and each recorded response helps clarify issues and preserve evidence. If escalation becomes necessary, this structured record can support cleaner filings and a stronger procedural position. In appropriate cases, it can also help support well-positioned requests for lawful interim measures, where available under Vietnamese law and where case conditions are met. The key is disciplined documentation, not volume. A foreign service provider faced a substantial unpaid invoice from a Vietnam-based client. The creditor had valid documents, but did not want to rush into litigation. LTS Law began with a structured soft collection plan, evidence review, a formal notice with a clear deadline, and a negotiation track directed to decision makers. The debtor engaged, a repayment solution was documented, and payment followed without a court hearing. Details adjusted for confidentiality. The takeaway is not that soft collection guarantees payment. Rather, it often creates the fastest route to a workable resolution when the debtor is still capable of paying. Many foreign companies confuse soft collection with being lenient. In reality, it is assertive, time-bound, and professionally framed, without rushing into procedural warfare. It is designed to secure cooperation, not to create delay. The objective is to keep the door open for settlement while making it clear that escalation is ready if commitments are missed. In Vietnam, a legally disciplined tone delivered through local counsel often carries more weight than distant threats or repeated internal reminders. A strong soft collection strategy runs on dual tracks: settlement progress and legal readiness. If the debtor stalls, avoids commitments, or shows evasion signals, we pivot promptly to the next step: formal demand, arbitration, or court, based on the contract and enforceability goals. Because the file has been built from day one, escalation becomes more efficient. The debtor also understands that the creditor is not experimenting, the creditor is executing a plan. We built this capability because foreign businesses consistently ask for one outcome: recovery without unnecessary litigation. Our cross-functional team combines communication discipline, negotiation management, and lawful background checks, supported by lawyers who can escalate when required. This structure allows us to move quickly, keep documentation clean, and tailor strategy to each debtor's behavior and each client's commercial objectives. If your business is owed money in Vietnam, do not jump straight to court, and do not wait in silence. Start with soft collection, done professionally, legally, and locally. LTS Law can assess your case, craft a structured strategy, and initiate action promptly. Visit lts.com.vn to begin. Because in Vietnam, starting strong does not mean starting hard, it means starting smart.